That was Lucy Adams, our social affairs correspondent, with a kind of cut-down version of what was in her BBC Disclosure documentary last night. As we discussed just a few minutes ago, though, there's been a bit of a knock-on from another aspect of that programme. It finished with some really dramatic and harrowing footage of Alan Marshall, who died at Saughton Prison in Edinburgh in March 2015 after he was restrained by, at different times, up to 17 prison officers. It turns out that new documents reveal that the decision to give those officers immunity from prosecution was incorrect, and if it hadn't been done, perhaps at least one of those officers could have been prosecuted. Let's speak to Tommy Ross, KC, about this. Hi, Mr. Ross.
Hi, Martin.
Thanks for being with us. Firstly, I mean, what's your reaction to that news about the case of Alan Marshall?
Well, from the report I read today, it seems that the Crown Office acted fairly quickly in giving the prison officers immunity from prosecution, and I think they accept that now, that they needed more information in terms of witness statements, and in particular they would have been assisted by the instruction of an expert report into the way in which the prisoner was restrained by the officers. And it seems that before they had such a report, they effectively gave the prison officers immunity. I
think I'm right in saying that the wording used in the programme was lifetime immunity from prosecution. Why would anybody ever get that?
Because they were cited to give evidence in a fatal accident inquiry. And there's always a concern that if the charge is hanging over a witness, then the witness will exercise his right of silence. So in other words, if all the prison officers had still been under the possibility of prosecution, they might have come to the fatal accident inquiry and refused to answer any questions.
Right.
So that's probably the reason for it, but I'm not in any sense justifying it, but that's the explanation for it.
Sure. I mean, is that common? I think a lot of people listening to this will be of the opinion that you should expect public servants to come and take an oath at a public inquiry and give the evidence that's required of them.
Well, if you think that, they're naive, because nobody's talking their way into a long sentence for culpable homicide, you know. So it's understandable if there's a possibility that the prison officers might be prosecuted for culpable homicide because of the way in which they restrained the individual, then it's reasonable to expect that they would take legal advice as to whether anything they said at the fatal accident inquiry might be used against them. Of course, they didn't have to have a fatal accident inquiry. They could have prosecuted the prison officers, or some of them, in relation to what was said that they did, and then there would have been no question of them having immunity at any stage, never mind lifetime immunity.
And now that option has been removed from them because they have this immunity.
So far as prosecution by the Crown is concerned, it's been removed. There could be a private prosecution.
Sorry to fixate on this issue of immunity. I mean, from what you're telling me, you've got a situation where somebody can arrive in court and give testimony, having been given immunity from prosecution, and then condemn themselves, or deliver testimony that would result in a prosecution. If I'm the family, in this case of Alan Marshall, how am I going to feel about that?
They're going to think they should have prosecuted the people rather than have an FAI. That's what I would think in that situation. Or at least should have fully explored the possibility of prosecuting them before they gave them immunity. You know, I understand that. I mean, that is the only reason why they would have given them immunity, so that they could have a purposeful fatal accident inquiry. I'm not in any sense suggesting that I understand that decision. You know, I don't understand it. But they did it, you know.
In a sense, Tommy, does the system need to change?
Well, they did something similar in the Glasgow bin lorry case, where the driver of the bin lorry was given immunity. So, and there was some public criticism of that decision. The difference was, in that case, the Crown maintained a position that they didn't have enough evidence to prosecute anybody. Whereas this statement, which you've quoted to me, suggests that maybe they're suggesting that at least one person might have been prosecuted had they held off until there was a proper investigation into it.
Indeed, it sounds like we may hear more about this, but thank you for your time this afternoon. Tommy Ross, KC there. It's just after 4:45.